Imagine being questioned by police after a traumatic event, stripped of your belongings and separated from your family, all while demanding answers about a tragedy. That's exactly what the Canero family experienced, and today we're breaking down a dramatic court transcript that pulls back the curtain on those tense hours, revealing a powerful cross-examination that challenges police conduct. Welcome back to Court Cam Commentary. Today we're diving into a crucial segment from a New Jersey courtroom, where a detective is on the stand, being rigorously cross-examined about the initial hours of a devastating investigation. The case involves the horrific deaths of Keith and Jennifer Canero and their two young children, Jesse and Sophia, in a Colts Neck mansion fire in November 2018. While this particular
neighbors offered them clothing or something like that?
I believe that's what occurred, yes.
Okay, so I just want to, I'm not trying to, there were initially, Mr. Canero, to your knowledge, had no shoes, but ultimately neighbors were trying to give clothes, right?
Yes.
And shoes to assist.
Welcome back to Court Cam Commentary. Today we're diving into a crucial segment from a New Jersey courtroom, where a detective is on the stand, being rigorously cross-examined about the initial hours of a devastating investigation. The case involves the horrific deaths of Keith and Jennifer Canero and their two young children, Jesse and Sophia, in a Colts Neck mansion fire in November 2018. While this particular transcript focuses on the detective's interaction with the accused, Paul Canero's immediate family, at the Ocean Township Police Department shortly after the initial fires, the attorney's questions are designed to expose potential issues with police procedure and the environment in which crucial early statements were obtained. It's a masterclass in challenging the narrative and planting seeds of doubt.
Okay, but what they wanted to do was change into their clothes, right? Is what they were expressing to you, unless I'm wrong.
How do we know what they want? How does this witness know what they want to do?
Here, the defense attorney immediately hones in on the family's initial state, specifically Mr. Canero not wearing shoes. This isn't just a minor detail, it's a strategic move. The attorney is trying to establish the family's vulnerability and unpreparedness, suggesting they were taken from their home in a hurry and without proper attire. This paints a picture of individuals who were likely disoriented and in a state of distress, which could later be argued as a factor in undermining the voluntariness of any statements made or the perception of their cooperation with law enforcement.
Sustained. No, that's not what they said. That's not specifically what they said. What did they tell you that they wanted to do?
I wanted a little bit of time to get cleaned up.
That's what they told you?
I believe, yes.
Okay. Just asking you not to put words into the detective's mouth.
Judge, can we approach?
No, not right now. Keep going. You can approach afterwards. You feel you can't continue.
This is a classic speculation objection, and the judge correctly sustains it. Under rules of evidence, a witness can only testify to facts they personally observed or heard. They cannot testify about another person's subjective thoughts, desires, or intentions, unless those were explicitly communicated to them. The detective can say, "They told me they wanted to get cleaned up," but not, "they wanted to change into their clothes," unless that was explicitly stated. The attorney quickly rephrases to focus on the detective's actual knowledge.
I just need a moment.
Take as much time as you need.
So I'm going to approach you with your report again, okay?
Yes.
And I'm going to take you to page 43 of 72. I'm going to direct your attention to this paragraph here, where you indicate The family requested some time to find new clothes and get cleaned up prior to responding to headquarters. Were those your words?
Yes.
Okay, so when I say new clothes, am I putting words in your mouth, or is that what you wrote?
A request to approach the bench or have a sidebar conference is common, particularly in jury trials, when attorneys want to discuss a legal issue with the judge outside the hearing of the jury. It could be about an objection, a procedural matter, or to argue a point of law. The judge's denial here shows a firm hand, indicating they want the cross-examination to proceed without interruption and are maintaining control of the courtroom. It also puts the onus on the attorney. You can approach if you literally cannot continue, implying that minor disagreements should be handled on the record or later.
That's what I wrote.
Okay, so to be clear, I'm not trying
Can
to...
I have counsel up here, please?
The Caneros wanted time before they went to the police station, correct?
Yes.
And what was your response to them?
I advised them that I would like them to come to the police station as quick as possible.
And did you also say that the reason why you wanted them to go as quick as possible is because as time goes on, their memory of events will not be as accurate?
Correct.
Okay. So you were concerned that if they took a little bit of time to get new clothes or cleaned up, that would affect their ability to somehow relate to you what had happened 7 hours earlier.
Could, yes.
Okay, so then, based on that, they agree, right?
Yes.
And they follow you, or you follow them, you tell me, to the police station, correct?
This is a brilliant moment of cross-examination. The attorney is using the detective's own report to contradict or clarify earlier testimony. This technique is often referred to as impeachment by prior inconsistent statement, or simply refreshing recollection. By directly quoting the detective's report stating the family requested some time to find new clothes and get cleaned up, the attorney cornered the witness. It underscores the importance of precise language in official documentation, and it demonstrates that the attorney isn't putting words in the witness's mouth, but rather holding them to their own written record. This directly aligns with principles found in Federal Rule of Evidence 613 regarding prior statements of a witness.
I believe I followed them.
Okay, so you follow them to the police station. This is the Ocean Township Police Department.
Yes.
And you testified that when you got there, you had them wait in the lobby.
Yes.
And did you tell them, like, this will be quick at first? Because you didn't know about the 15 Boulevard situation yet?
I don't recall if I gave them a time frame.
Okay. So you had them sit in the lobby for some time. And then you testified that you brought them down to the basement?
More or less of the building, yes. It's just where the detective is located.
Okay. And that's specifically into a conference room, correct?
Yes.
And you put all 4 of the Caneros in there?
Yes.
And is there cell phone service in that conference room?
Yes.
There is, okay. And at some point, though, you separated the family members into interview rooms.
At some point, they were separated for their statements, yes.
Okay, but not one by one. You separated like two from one from another. Do
Yeah, I
you
don't recall.
that?
The attorney is systematically dismantling the idea that the family's agreement to go to the station was entirely voluntary or uncoerced. The detective stated concern that memory of events will not be as accurate if they took time to clean up, especially after the incident was already 7 hours prior, sounds disingenuous. This line of questioning tries to establish that the police manufactured urgency to get the family to the station immediately, potentially influencing their ability to make free and informed decisions. This builds a foundation for later arguments about the voluntariness of any statements obtained, which is crucial under the Fifth Amendment's protection against self-incrimination and the Miranda rule.
Which room everyone was in the detective, we used separate offices to take the statements.
And did you lock those rooms? Did you lock them in the rooms?
I don't believe so.
Now, at one point, the family members, you testified they were very upset. They were learning what was happening, right?
Yes.
And they learned it, I think you said initially through a family friend.
The original fire.
The original fire.
Correct. They received it. Someone in the family received a text message.
And then later they're learning through media updates about someone being deceased at 15 Willowbrook.
Yes.
And you said they're demanding answers.
They want, yes.
And approximately what time is this?
(1:30 to 2:30 ball. I don't remember. 2 o'clock.
Okay.
I'm not sure.
And when they're demanding answers, like what do they want? They want to know what? Like what's happening?
Sustained speculation.
Why didn't you give them answers to their questions?
Didn't necessarily have.
This transcript offers a rare glimpse into the intense scrutiny police procedures face during cross-examination, especially in high-stakes cases. This specific case involves Paul Canero, who stands accused of the brutal murders of his brother Keith, sister-in-law Jennifer, and their 2 children Jesse and Sophia, in a horrific fire at their Colts Neck, New Jersey mansion in November 2018. Prosecutors allege he also set fire to his own Ocean Township home to create a cover-up. As of February 2026, Paul Canero's trial is actively underway in Monmouth County Superior Court. Opening statements began on January 12, 2026, and after 5 weeks of testimony, the jury is now near or has begun deliberations. Canero faces multiple charges, including 4 counts of murder, aggravated arson, weapons offenses, and theft. If convicted, he could face life imprisonment without parole. The defense maintains his innocence, arguing that authorities fixated on Paul Canero from the start and failed to investigate other potential suspects. We'll be keeping a close eye on this case, and will bring you updates as they become available.